everybody, Kelly Henderson here again to talk about self-defense today. In the state of Georgia, you are allowed to defend yourself or a third party from harm being caused or imminently about to be caused by another. And so I just want to discuss the statutes that address this in the state of Georgia and some of the incidents that I've seen personally and how, you know, the landscape is in the state of Georgia right now with regard to self-defense. And I'll tell you, unfortunately, it's a little bit all over the place. It depends on a lot of factors. Probably the most important factor would be, what did the police officers believe happened when they show up and when they're at the scene trying to assess the situation? Also, who's the prosecutor assigned to the case? What are their feelings on self-defense? Who is the judge assigned to the case if you happen to get arrested? What are their feelings on self-defense? This is a landscape that is dominated by the opinions of people. The beliefs are on a spectrum of belief with regard to self-defense, and so, your life and your ability to defend yourself will be judged by other people. You do not hold all the cards. You will not have the authority to just tell the police what happened and expect that they're going to believe you and let you go immediately and that you'll never have to deal with the court system. So here's what the law in the state of Georgia says. You are allowed to defend yourself or a third party. You are allowed to defend yourself from the unlawful and imminent use of force, meaning you're allowed to defend yourself when someone hasn't quite yet laid a hand on you, so long as you reasonably believe that that force is imminent and that your defense is necessary to prevent that imminent and unlawful force. Of course, you're also allowed to defend yourself once someone has begun to use force against you that is unlawful. Now, you're also allowed to use deadly force or use force that is going to cause serious bodily injury. I believe the language that they use is great bodily harm in the code section, but you're allowed to use force that could cause death or great bodily harm so long as the force that is unlawfully being used against you or about to be used against you is proportionally going to cause death or great bodily harm. Or you're also allowed to use deadly force if you're going to stop a forcible felony, like an armed robbery. So that's what the law says. Those are the words that the law uses. Must be a reasonable belief that you are at least in imminent danger of the use of unlawful force against you, okay? So if it's unlawful force, that means the person doesn't have the right to use it against you. If a police officer is forcing you into a set of handcuffs because he pulled you over for a DUI and you've been drinking all night, well, the officer has the right to do that, and you can't start using force against him. You'll get an obstruction charge, and you won't be able to say, well, it was unlawful force. Imminent. This is a big problem. What does imminent mean? If no one has laid a hand on you, well, what does imminent mean? I mean, is the person 20 feet away? There's a lot of videos about the 21-foot rule. That's not something that exists in the state of Georgia. But is someone right in front of your face? What are they saying to you? What is their body language like? What are the witnesses around the situation going to say? If there are no witnesses, how are you going to describe to the authorities when they arrive what happened? And will they believe you? Will they believe your story? And that's a lot to process in a short period of time when you're in danger, and it's kind of the last thing you're going to be thinking about. But this is the problem with how the law works. It's a Monday morning quarterback situation. You don't know what the people who are doing the Monday morning quarterbacking are going to think about this whole thing, what they think about the use of force at all or guns. and your ability to use them in the particular situation that you were in, and if they even get the real assessment of what that situation was like. So be cautious whenever, I mean, pre- preventative solutions are the best. Don't put yourself in bad situations. Don't put yourself in a situation where you would have to use this force. Don't flirt with this thing. You really want to stay away from it because, well, I've just seen in my experience where a situation that I think I would use self-defense, um, well, it wasn't seen that way by the judge. It wasn't seen that way by the police who arrested the person. It wasn't seen that way by the district attorney's office that was prosecuting that person. And a judge might rule that you weren't allowed to do it. So be extremely careful. Of course, this is your life. You should be careful with that anyway. But don't have a cavalier attitude walking around this world thinking that you know when you can use force and it's going to all be very easily cleaned up after the fact, and that you won't get arrested and have to deal with the court system and have your life affected for a very long time by the situation, even if it was lawful. Um, I like to say God's not going to come down and be a witness and set everyone straight. So again, be very careful with your life and the situations you put yourself in. Avoid having to deal with the court systems altogether if you can. But if you can't, then the rules are you have to be in reasonable fear of imminent unlawful use of force by the other person. A person does not have the right, a complete stranger does not have the right to punch you. That is a battery. And if someone punches you and you're not giving them any reason to feel like they need to defend themselves, then you have the right to defend yourself to the extent that it takes to stop that. Now, you can't use deadly force in that situation, but you do not have a duty to retreat. If someone punches you for no reason, Georgia is a stand your ground state, as the saying goes. You have no duty to try to retreat and avoid using your own force. You can just punch them right back. Now, if you punch them and they stop and they walk away, you can't follow them around and, beat them to death. You can't pull out a gun and shoot them. Once the situation is de-escalated, it's over with. The ability to use unlawful force goes away. If they punch you, you punch them back, they punch you again, well, you're allowed to continue the use of force until the unlawful use of force against you is over with. Of course, even in fist fighting, this causes problems, right? If someone's bigger than you, if they're powerful, if they know what they're doing, or if they just won't stop, well, when does the use of fists against you turn into the reasonable belief that you're in imminent danger of serious bodily injury or great bodily harm, as the law says, or death? People can die from getting punched repeatedly over and over in the face. Or if you become incapacitated, then where does that leave you with regard to this person who's attacking you and what they can do to you? This is where it gets tricky. This is where I've seen it over and over again. People who are judges, law enforcement officers, district attorneys, they don't necessarily have a great education on the dynamics of fighting, how a fight with fists can turn deadly. I mean, choke people out, strangle somebody. You can do horrible things to somebody with your fists. Once somebody's on the ground after being punched, the feet come into play. Someone can get stomped. Bones can easily break. Skulls can easily get cracked. Heads can be smashed against the pavement. A fight that involves nothing but hands and feet can be deadly. And so when do you decide in this horrible situation that's unfolded, possibly completely by surprise to you, that you have the right to pull out a concealed carry firearm and shoot? It is very tricky. I have seen it where a judge, a district attorney, an officer. It's like, well, this wasn't self-defense. He was just using his hands against you. They arrest the person. The district attorney's office decides to prosecute the case. The judge, in an immunity hearing, decides, well, they were only using hands against you. You weren't in that much danger. You can't use a gun. You should not have shot this person. You should have continued to use your hands to defend yourself. So there's this issue of proportionality of force. If you're just in a fist fight, and it looks like that's all the fight's going to be, how do you can't pull out your gun and shoot the person. I mean, the law tries to prevent this over proportional response from a person that's in a fist fight. But obviously, fist fights are there's a pretty wide range of fist fight. Just because something starts off as a fist fight doesn't mean it's going to remain a fist fight. Just because something starts off as a fist fight doesn't mean that the person's not going to change their mind and decide to put you in a chokehold and choke you to death, or bang your head against the pavement until your skull's cracked and maybe you're dead, maybe you have lifelong brain damage. And if this isn't a fight where you and your friend, who you know is not going to go over the line of, starting to bash your head into the ground and going to keep it a boxing match, if it's a stranger in a bar, you have no clue who they are or how far they're willing to go, then I would say I would be very concerned about a person who started a fight with me in a bar and I have no clue how far they're willing to go, if they're trained in jiu-jitsu or some other martial arts that would give them the ability to kill me, or if they're willing to smash my head into the ground, or suddenly pick up a bar stool and start beating me over the head with it, or do they have a knife on them? Do they have a concealed weapon on them? I mean, these are things that you wouldn't know if a fist fight popped off with somebody that you don't have any prior knowledge of. So the situation gets very tricky, because a lot of people, even law enforcement officers, judges who have handled cases, criminal cases their whole life, they're not always thinking that way. They're not thinking like, hey, this guy didn't know the person. He didn't know whether or not he had a knife, or if he had one, was he willing to pull it out and start using it, or is he willing to start bashing your head into the ground? A lot of times what I've seen is they just draw a pretty simple line for themselves. Hey, this fight only involved fists. So the person, even though the victim had the right to defend themselves, they only had the right to defend themselves with their own fists, or with a weapon that was not going to cause great bodily harm or death. And so if you have a concealed carry permit, or you carry a pistol concealed, and you're walking around thinking, well, hey, if someone starts a fist fight with me, I'm just going to pull out my gun and shoot him. You need to think twice about that, because that's not necessarily how the courts are going to look at it. Some courts will. Some police officers will. Some police officers would go to a scene and see that someone been shot. Maybe they're alive, maybe they're dead. And you tell them, hey, this guy just came at me out of nowhere, punched me in the face. I had no idea what he was going to do or if he was going to stop. So I pulled out my gun and shot him. And they would be like, okay, that's fine. That's imminent. That's a reasonable, imminent fear of great bodily harm or death, because the guy had already punched you. That's imminent. That's beyond imminent. And you have no idea what he's going to do to you. That's reasonable. So he could have committed great bodily injury or death to you, so you had the right to shoot him. Case closed. They're not even going to slap the cuffs on you. You can have other situations where the police officer shows up and just says, well, he was just using his fist. What, you don't know how to fist fight? You're afraid of a fist fight, so you pull out your gun and you shoot a man. They arrest you. The district attorney's office says, yes, this is a good arrest. And then at an immunity hearing, which is what happens, a lawyer who's representing you, who knows the law, knows that you file a motion for an immunity hearing for self-defense. You go in front of the judge and you say, Judge, well, this person hit my client in the face. My client had no idea who this person was, had no idea what this person was capable of, had no idea that this person did or did not have a gun or a knife on him. And so he shot him to defend himself because he reasonably believed that he was in serious danger of death or great bodily harm. And the judge will say, well, this was just a fist fight. You can't shoot somebody. You can't bring a gun to a fist fight. And then they make you go to trial. They deny your immunity from prosecution for self-defense. And then you have to go to trial, and maybe a jury sides with you. You bring up the same defense in front of the jury. Maybe they side with you. Maybe they don't. And if they don't, then you're going to prison and you'll have an appeal. Maybe the appeals court will side with you. But that's a lot to go through. That's going to be years of your life spent on this issue, which is why I urge the preventative course of defense, which is stay away from bad situations. Stay away from bad situations where bad people are around. Try to de-escalate. Try to get out of there. Try to do anything you can do, even though there's no duty to retreat. There's not a duty to retreat. But if you can safely retreat, take that course. Don't let pride take over or ego take over. Don't think that you know that everyone's going to be on your side after this is over with, and just pull out a gun and shoot somebody. Now, if the other person has pulled out a gun or clearly has a gun on them, or you know that they have a gun on them, or they're saying they have a gun on them, it looks like they've got a gun on them, and they punch you in the face, that does change the landscape, as long as that's provable to the third parties who are going to be involved in the situation, like the police, the district attorney's office, a court. But when it comes to just a fist fight, it's a really wide gray area on whether you're able to use a gun to defend yourself. In the case law, you can see where it's known that somebody does have a weapon, or you knew that the person from previous incidents has used a gun on somebody or a knife on somebody or kept their gun on themselves. That changes the landscape. It's very factual. It's very case specific and fact specific. But again, you are going to be relying on third parties, the responding officer, the district attorney's office, the judge, to decide your fate. And so before you ever bring them into the situation, when the fate is completely in your hands, I would say do whatever you can to get out of there, to avoid situations or get out of situations or de-escalate situations without ever having to resort to the deadly force that you may have on your person in the form of a gun or a knife. I do believe in your right to carry the gun. I think it's something that we should all do. I believe the world would be a much safer place if everybody knew that people had guns on them. But when you have your fate in your hands, I would say do everything you can to not have to use that force, so that third parties aren't coming into your life and deciding the course of your life in a major way. So now, after that overview, you also have the right to defend third parties. It's the same calculations, reasonable belief that you need to defend yourself from, or defend a third party from the imminent use of unlawful force on the third party. If it's deadly force, you can use deadly force. Or if it's a forcible felony, you can use deadly force. Again, an armed robbery. If someone's pointing a gun at somebody saying, give me all your money, you can use force that can cause death or great bodily injury. You can also defend your habitation. You can also defend property or third parties and their property. That, again, the armed robbery example applies there. If you're arrested for the use of force and you believe that it was justified, then your attorney should file a motion for immunity. You would go in front of a judge, you would present why you believe your force was justified. The judge would hopefully decide in your favor. If they do, the case gets dismissed, the prosecution is not allowed to take the case any further, and it's all over with. Although the judge may decide not to side with you, and then you have to go to a jury. You can make the same case in front of them. Hopefully they side with you. If they don't, then it's an appellate court, and an appellate court may side with you as well. So there's a lot of different people you can make your case with. It'll take a lot of time. It'll be something that you wish you never had to deal with. And they can decide ultimately that you did not have the ability to use force. And of course, in a situation where you're in fear, there's a threat coming at you, possibly already hitting you in the face. This is a lot of technical calculations that you're being expected to make in order to comply with the law. And I don't think that's a very reasonable thing to think that you're going to be able to do, unless you had a lot of practice, either doing simulations with people, with some of these companies that give simulation training, or if you're a fighter, you've practiced martial arts and you've been in these situations a lot, and you have the ability to think during these kinds of episodes. But even then, being able to run the calculus that the law wants you to run, it's not something that I would rely on. So that's why I say do your best to stay out of dangerous situations. Do not flirt with this type of thing, and do not walk around thinking that the people who are involved are just going to automatically be on your side and understand the way you were thinking and give you a pass on your use of force. So that's my quick spiel, my quick rundown. So that's my quick rundown on the use of force. Please let me know if you have any questions, and I'll try to address them. Thank you.